Go ahead.
All right, I'm gonna call the policy committee meeting to order at 6:06. Maureen's not joining us.
I was not informed.
So we have a bunch of policies for review. These are all ones we've seen before. They've been updated to meet current legislation changes. So the first policy is 1370, non-discrimination, and the associated regulation. We don't vote on the regulation, but it's there with the same changes as the policy. The Shipman and Goodwin notes provided in your policy summary. Shipman and Goodwin say passed during the 2025 legislative session, Public Act 25-139 adds sexual assault victim and human trafficking victim as protected classes under Connecticut's non-discrimination laws. This policy has been revised to reflect these additions, also updated the location and contact information for the U.S. Department of Ed, Office for Civil Rights, as the Boston office is closed. In addition, the appeal timeline for complaints involving superintendent or a member of the board has been aligned with the timeline applicable to the respondents. And then there are some technical revisions. So there's not actually a lot of changes, just the ones that I just read. So we could talk about recommending to waive the second read on this. It's in the 1300 series. The regulation is provided, see pages in it regarding the sexual assault, human trafficking edition. Do you have any questions or comments? Galen?
I think we should wait a second.
Yeah, there's not a lot of changes and it's small, minimal. But
Got to comply with legislative changes.
yeah, there's not a lot of changes, but it's necessary. And wanted to get this done, relatively soon. So we're gonna waive the second read or recommend that the board waive the second read. Okay. Then the next policy is 4116.1, sex discrimination and sexual harassment. Shipman and Goodwin is also an associated regulation with this. On January 9th, 2025, the Federal District Court of Kentucky ruled that the 2024 Title IX regulations, which had taken effect on August 1st, 2024, are invalid and must be set aside. January 31, 2025, the U.S. Department of Ed's Office for Civil Rights confirmed that effective immediately would enforce the 2020 Title IX regulations. Accordingly, boards of ed discontinue use of policies and regulations that follow the 2024 Title IX regulations and resume using those that were in place under the 2020 Title IX regulations. This policy has been revised that complies with the 2020 Title IX regulations and also updates the location of and contact information for the U.S. Department of Ed, the Office for Civil Rights Office, where individuals may file complaints, because again, the Boston office has closed. It also adds reference to the potential use of a third-party contractor to conduct investigations. And it removes the definition of fondling within the definition of sexual assault and replaces it with criminal sexual contact. It updates the definition of rape pursuant to the changes to the National Incident-Based Reporting System manual and clarifies certain distinctions between federal law and Connecticut law. So again, there's not a lot of changes in this. If you read through, this is 4116.1 in the personnel series. It's minimal changes. I would suggest that we recommend to the board to waive the second read on this one as well. And you can see the same changes are in the regulation 4116.1, sex discrimination and sexual harassment.
Thank you.
Okay. The next policy is 4118.1, non-discrimination. Again, this is in the personnel series. And the associated regulation is the same essentially as the non-discrimination in 1370 with the same changes. Adds sexual assault victim and human trafficking victim as protected classes, updated location and contact info, technical revisions, and change the appeal timeline for complaints. So it's the same changes made in 1370, but it's in the personnel series. We're good to also waive the second read. So then the next one is 5020.1 non-discrimination. This is the exact same policy in the 5,000 series, which is the student series. Same changes, same information. Wait a second, read, okay. Then we come to applications here. All right, so now we're at 5110.4, student discipline. This was formerly suspension, expulsion, exclusion from school and school activities. I'm gonna go in, say, as noted above in 2023, the General Assembly passed legislation now codified at Connecticut General Statute Section 10-222 AA, making significant changes to the statutory provisions related to school climate. Among other things, the revised law contains a new definition, again, of bullying and requires boards of ed to address challenging behavior in accordance with the revised school climate law. In light of these changes, they've revised the student discipline policy to reflect that, when appropriate, the school district will implement strategies to address student behavior consistent with the school climate policy, with or without engagement with the discipline process. This revised policy also incorporates the updated definition of bullying and the definition of challenging behavior. In addition, the definition of protected class has been expanded again to include victims of sexual assault or human trafficking as required by Public Act 25-139. They also expanded the list of conduct that may lead to disciplinary action to include the use of language, imagery, symbols, or conduct that demeans, threatens, or discriminates against an individual on the basis of their membership in a protected class. Language concerning the unauthorized possession, display, or dissemination of images depicting nudity, including synthetically created images, has also been updated to reflect the federal Take It Down Act and recent changes to Connecticut law. They've also included an opportunity for boards to expand the policy's definition of generative artificial intelligence, AI, to include more systems than just ChatGPT. The revised policy also incorporates new procedural requirements for suspension and expulsion hearings. Specifically, Public Act 25-93 requires school personnel to consult with the district's local homeless education liaison to determine whether a student is homeless, and if so, to consider the impact of homelessness on the student's behavior before proceeding with suspension or expulsion. Policy has also been updated to ensure compliance with the IDEA when a student who is eligible for special education and related services under the IDEA has been suspended for 10 school days in the same school year, even if not consecutive. In that circumstance, the district must provide such student with services to enable the student to continue to participate in a general education curriculum and make progress toward meeting the goals in the student's IEP. Finally, legal references throughout the policy have been updated to reflect current statutory citations. So even though this is, there's a lot of changes in this one, I would not recommend waiving the second read on this one. It is all still trying to be compliant with changes in federal and state laws and definitions, et cetera, but it's a lengthy read with a lot of changes, so I would recommend not waiving it. But were there anything that you wanted to discuss about this particular policy? Anything? No? Okay.
I will just say that administrators were trained on this over the summer and we are implementing them under the new policy now.
I think we see that one at least once a year, not
Right.
more.
Yes. Yeah, it feels like we're constantly trying to play catch up. And I think there'll be changes further from what I'm hearing already. This
Yay.
this session. So.
We get to look at it again.
Yeah.
Okay, great. Awesome. Looking forward to it. All right, 5120.3.3 administering medications in the schools, formerly administering medication. Under Connecticut General Statute, Section 10-212A, qualified employees of boards of ed are permitted under certain circumstances to administer epinephrine or glucagon to students. Public Act 25-143 revises the statutory language to authorize boards to use a wider range of medical equipment, for example, nasal spray, instead of limiting boards to injection-based delivery. We have revised the policy to reflect the updated language in the statute regarding medication delivery systems or mechanisms. In accordance with the provisions of Connecticut General Statute, Section 10-212AA2 and Section 10-212A2 of the regulations of Connecticut state agencies, any proposed revisions to the administration of medications policy must be made with the advice and approval of the school medical advisor, the school nurse supervisor, or other qualified licensed physician. So this, there's not a lot of changes. The same definitions as before.
Still strictly administered and controlled.
Yes. I mean, there's like a couple of language. It's mostly so that it's not restricted to injectables.
Right.
Other than that, there weren't any other changes that I saw. Section that I read. Thought, question. So do you want to recommend that we waive the second read on this one? I mean, it's a long policy, but not a lot has changed except for the few ones.
I would waive it, just to emphasize that it's just changed away from the injectables to the nasal spray, to make sure everybody knows it. Beyond that. To include.
Yeah, our nurses would be appreciative of that, because that students have been bringing in nasal spray, which obviously is much easier to
Yeah,
administer.
okay, so if we wait the second read, we can get it through faster. And be compliant with faster. Okay. Good times. All right, so last one, 5120.
Can I ask, speaking of being able to do it faster, if we already have like the handbook in place and parents sign that, does this have to wait until next fall to go into effect? Or
No, because any policy that you approve supersedes anything that was previously approved on it. If it was anything that was a huge substantial change, like a dress code or something like that, we would send it out to parents. But
Yeah.
something like this, we would just update the website and then
the
update.
impacted students would be told, like, you can tell your parents, you can use the nasal.
Yeah,
Okay.
yeah.
The last policy, 5120.5, prohibition of sex discrimination and sexual harassment. Changed the title from Title IX of the Education Amendments of 1972. That's crossed out now, so it'll just be prohibition of sex discrimination and sexual harassment. On January 9th, 2025, a federal district court in Kentucky ruled that the 2024 Title IX regulations, which took effect on August 1st, 2024, are invalid, must be set aside. This is the same policy change as the one that we already discussed about sex discrimination, or prohibition of sex discrimination, the 4116.1, which is under personnel. And so this is the same changes in the student section, 5120.5. So it's the same, going back to the 2020 Title IX regulations instead of the 2024. And policy is revised to comply with those and removes Title IX from the title of the policies and regulations. The associated regulation is included in your packet. It is a short policy. It's the same changes as, again, 4116.1, but in the student section. I think we could waive the second read on this one. All right, so then we're recommending that all these policies move forward to the board. With the exception of 5110.4, we'll waive the second read. And that's it. Do we have any public comment? No, there's like not tons of people out there. All right, then I guess we'll adjourn at